Hi, my name is Jake, and I'm an attorney with Idaho Legal Aid, and I'm going to be sharing some information in this video about using evidence in court. Now, these are just general principles and are intended for educational purposes only. If you need legal advice, please consult with an attorney. The Idaho State Bar has a referral service you can use. You can also apply for services through idaholegalaid.org, but your case is way more important than any YouTube video. So please keep that in mind. Now, regarding evidence, properly presented evidence can be very important to any case. Evidence can mean different things in different situations. In a civil protection order, for example, screenshots of text messages, photographs of alleged injuries, uh, voicemails, videos, these are things that the court might consider when making a determination. Now, for evidence to be uh, used or make a difference in any case, all evidence needs to meet the three R's: relevant, reliable, and ready for the court. So, regarding relevant, relevant means that the evidence that you are presenting will help the judge determine what happened and how the law applies in that situation. Essentially, to be relevant, evidence needs to be directly related to what the judge has to decide. It also needs to help the judge by showing something is less likely or more likely to be true. All evidence must be relevant to be considered by the judge and could be excluded if it's irrelevant. The next R is reliable. All evidence needs to be reliable. Evidence such as documents, photographs, they all have to be true and accurate. Evidence has to come in through a witness, meaning that someone has been sworn in to tell the truth and can give some testimony that the exhibit is what they say it is. When a witness testifies that the exhibit is what they say it is, this is called laying the foundation. Much like a building has a foundation to stand on, evidence that is presented in court needs to have a foundation too. Foundation changes given the types of evidence, but there are some common themes. Describing where the evidence came from or how it was documented. For example, a screenshot. Someone could testify about how the screenshot was taken and when and where. The who, what, where, when, and why questions learned in school are very useful when laying foundation. But in order to be reliable, the court's going to have some information so that the judge knows that the document or the video or the screenshot is actually what the person is alleging that it is. The final R is ready. The evidence needs to be ready for the court to use and for the evidence to become part of the case file. 3 copies of the evidence should be brought to court, one for the clerk and the court, one for the record, one for the opposing party, and then one for the person presenting it. The documents need to be exact duplicates and as high quality as possible. If the original is available, that needs to be brought, and then copies made of that for the to use in court. Evidence should not be altered, written on, drawn on, annotated. They need to be the exact same and be the original if possible. Now, for digital evidence, that's going to need to be printed out hard copy. If the screenshots are shown on a cell phone, there's a chance that the court might take that cell phone and make it part of the permanent court record of that proceeding. So that's why it needs to be printed out. If someone wants to play audio or video recordings, they're going to need to bring some equipment to make that happen. Don't rely on the court playing the audio or video or being ready to do that. Sometimes it's useful to talk to the clerk beforehand to let that person know that there's going to be some audio or visual used, and the clerk might have some information about how the judge might want that to happen. The judge also needs to be ready to receive the evidence. So, asking permission about approaching the judge's bench or giving a copy to the court or playing some sort of audio or video recording is important. And the judge will always appreciate the respect that comes with that. One way to get some audio or video recording into the record would be to put it on a thumb drive and bring a laptop that could maybe be hooked up to some speakers in the room. And that way the recording or audio or visual or whatever could be played on the laptop, and then that thumb drive could be given and made part of the court record. After the exhibit is presented to the court, it's also important to ask that the judge admit the evidence into the record so the judge is ready to receive it. Just as a wrap, these are resources. There's a lot more available on idaholegalaid.org. There's also information about our services there. I am going to link down below to a document by the National Council of Juvenile and Family Court Judges that has some additional information about presenting evidence in court as a pro se litigant, and it's a great document. But as I mentioned, again, this was just for educational purposes only. It's really important that if you have a legal situation that you talk to an attorney who can advise you about your specific situation and what you specifically need. Take care.